இந்திய அரசியல் சட்டத்தை வடிவமைப்பு செய்து கொடுத்த ஒருவரை எவ்வளவு கேவலப்படுத்த வேண்டும் என்று நினைக்கிறார்கள். இல்லாத ஒரு கற்பனைக்கு நாம் மரியாதை கொடுக்க வேண்டுமா? இல்லாத கற்பனையை தூக்கி கொண்டாட வேண்டும் என்றால் அப்ப அவங்க நோக்கம் என்ன? அவனுக்கு பொது அறிவு இருந்திருந்தால் மாட்டு மூத்திரத்தை வாங்கி முகம் கழுவக்கூடிய அவர்கள், மாட்டு மூத்திரத்தை வாங்கி தலையிலே தெளித்து கொள்ளக்கூடிய அவர்கள், மாட்டு மூத்திரத்தை வாங்கி உள்ளுக்கு சாப்பிடக்கூடிய அவர்கள், மாட்டு பாலை மக்களுக்கு பயன்படக்கூடிய உண்ணக்கூடிய பாலை கொண்டு போய் கல்லிலே ஊற்றக்கூடிய அடிமடையர்களே, உங்கள் கையிலே இந்த சட்டம் சிக்கிக்கொண்டு எவ்வளவு சீரழிவை அடைந்து கொண்டிருக்கிறது. சாணியை சாணியாக பார்ப்பது நம்பிக்கை, சாணியை சாமியாக பார்ப்பது மூட நம்பிக்கை. சாணியை சாணியாக மட்டுமே நாங்கள் பார்ப்போம், அதை எருவாக பயன்படுத்துவோம், எரிபொருளாக பயன்படுத்துவோம், ஒரு வாயு பொருளாக பயன்படுத்துவோம். ஆனால் சாணியை நீங்கள் சாமியாக பிள்ளையாராக வழிபடுகிறீர்கள். உங்களுக்கு பக்தி இருந்தால் புத்தி இருக்காது, புத்தி இருக்கிறவனுக்கு பக்தி இருக்காது என்று எங்கள் தலைவர் பெரியார் அன்றைக்கே சொல்லியிருக்கிறார். அப்படிப்பட்ட இந்த மதவாதிகளை, மௌடிகத்தில் ஆழ்ந்திருக்கக்கூடியவர்களை, மத நாடாக இந்த நாடை ஆக்க வேண்டும் என்று மனப்பால் குடித்து செயல்படக்கூடிய அவர்களை, அவர்கள் முயற்சியை நாம் எதிர்த்து முறியடிப்பதற்கு தந்தை பெரியார் கொடுத்த பேராயுதமான நம்முடைய கழகத்தின் தலைவர், தமிழர் தலைவர் ஆசிரியர் வீரமணி அவர்கள் தலைமையிலே நாம் மோடி அரசை வருகிற 2026 வீழ்த்துவோம் வீழ்த்துவோம். அந்த ஆட்சி வீழுகின்ற நாள்தான் இங்கே ஜனநாயகம் தழைக்கக்கூடிய நாள், மதச்சார்பற்ற தன்மை தழைக்கக்கூடிய நாள், சோசலிசம் மலரக்கூடிய நாள், சமத்துவம் மலரக்கூடிய நாள், மனித உரிமைகள் மதிக்கப்படக்கூடிய நாள் என்று சொல்லி தலைமை உரையை நிறைவு செய்து அடுத்த அறிஞர் பெருமக்கள் இங்கே பேச இருக்கிறார்கள். கேட்டு பயன்பெறுங்கள். இந்திய துணைக்கண்டம் முழுவதும் இந்த கருத்துக்கள் எடுத்து செல்லப்பட வேண்டும். பெரியார் என்ற அறிவு சுடர், பகுத்தறிவு சுடர் நீங்கள் பஞ்சாபிலே தூக்கி செல்லுங்கள், மக்கள் மத்தியிலே கேரளத்திலே தூக்கி செல்லுங்கள், தெலுங்கானாவிலே தூக்கி செல்லுங்கள். அப்படிப்பட்ட வாய்ப்பு உங்கள் கையிலே கொடுக்கப்படுவதற்கு அடையாளம் தான் இந்த மாநாடு. மாநாட்டை நடத்திய மாநாட்டினுடைய அமைப்பாளர்களுக்கு எங்கள் நன்றியை, வணக்கத்தை பாராட்டி அமைகிறேன். நன்றி, வணக்கம்.
நன்றி. Rest of this session will continue in English. I request our senior advocate of Madras High Court, Dr. A. Tyagarajan, to deliver his special address.
Good afternoon, become good evening. The topic given today is about the implications of the new acts relating to the rationalism and the freedom of speech. The new act has nothing to do because the old act is as it is, with some improvements, some additions, or tightening the freedom of speech and expression. Beyond that, the new act has no other implications. The Criminal Procedure Code has been renamed as Bharatiya Nagarik Suraksha Sangeeta. Name is changed, but substance is one and the same, with a little bit modification of the procedure in the court of law, taking the complaint on file. Indian Evidence Act is the same act which has been amended, introducing section 63 instead of old 65, by giving 2 certificates for the purpose of production and admission of electronic evidence. Let me tell you what are the new additions in the Indian Penal Code. That is the present act. The additions are the word child has been interpreted increasing the age from 12 to 18. So from this act, a child means the child which is not crossed 18 years of age. Then gender includes male and female, now included transgender. Then the calendar is, British calendar is now replaced by Gregorian calendar. There is no change in that, monthly days and everything is correct. Then regarding the property, they have removed corporeal property within the definition of property. The insane person has been introduced in the place of a person consent of guardian. It's under age of 12 years. So now 18 years have been reduced to 12 years are just this definition. Then punishments are concerned, other punishments are there. Now they have introduced community services. Also a punishment. Community services are nothing but they will not be sent to jail. They will be allowed to do some work without remuneration. Say for example, regulating the traffic or going to some libraries and managing the libraries. So like that some work will be given. So that is the new addition regarding the punishment. Then exception to the sexual offences has been introduced. One exception has been given in the course of section 63. Then new section has been introduced, section 69, whoever deceitful means or by making promise to marry to a woman without intention, that is an offense. Nowadays people are living together, they are living together. After some time they go for their own way of life and lodges a complaint. So to curb all these things, the new section 69 has been introduced. It also says that at the inception he must give a promise. Then another definition is age of the victim has been raised to 18 years instead of 16 years when it got married. Then section 84, abduction. Then one new section has been introduced, section 95, that is hiring of employees of engagement of children, which has been brought now to the punishment. The other one new section is 103, punishment for murder when a group of 5 or more persons have committed offense on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such. These are all introduced because of the honor killing or something like that. These have been imposed. The life imprisonment means rest of the life, not 14 years as the present law. Then the other definition is section 303, a life convict murders commits another offense of death, he will be sent to jail for the remainder of his life. Then 304A, doctor has been included, negligence. A new section has been introduced, unlawful activities, including so and so and so and so. Then another new section has been introduced, section 112, group or gang either singly or jointly commits any act of theft, snatching, so and so have been introduced. Section 320 of the old act has been modified, section 116H. That is, when a grievous hurt is there, earlier act says 20 days, the present act gives 15 days. And new section 117.3 has been added, whoever commits offense of voluntarily causing grievous hurt, the punishment has been given. Another new section 117.4, again group of person commit voluntarily causing grievous hurt, and the earlier section 326 has been introduced now into 124.1, and act in new section has been introduced, section 152. This is a dangerous section. Section 152 can be interpreted and booked any person, therefore it is a dangerous section, it is ambiguous. I will read the section. Whoever purposely or knowingly by words, either spoken or written or by sign or by visible representation or by electronic communication or by use of financial means or otherwise excites or attempt to excite secession or armed rebellion of subversive activities or encourage feeling of separatist activities or endangers sovereignty or unity and integrity of India or indulges in or commits any such act shall be punished with imprisonment for life with imprisonment. This section is an omnibus section. It covers everything and the punishment is life. So the cause of the act is to be corroborated with the punishment. The punishment should not exceed the act of the person. So this section, it is an omnibus section 152. It is dangerous and it can be manipulated and can be used. The other section is 226, committing suicide. So earlier it was there. The same thing is there with slight modification. The other section is amendment of section 293 and 295. This is, the age is increased from, for the purpose of child, 21 years is replaced by child, thereby cultivated so and so. The other new section is 324(5), damaging the properties, and the penalties have been increased so much of 1 crore, 1 lakh and 5 years. And the other new section is 152. I said last section was 103, and now this another section is 152. This is relating to the punishment of for the act of words either spoken or written or by sign or by visible representation or by electronic communication or use financial than otherwise sites attempt to excite secession or armed rebellion. This section is also very dangerous section which will lead to manipulations and registration of cases by abusing the process. The other section, new section is section 435, now 326F, including agricultural produce has been included, the new section for the purpose of mischief. And house trespasses by night has been replaced by the word sunset and before sunrise. Similarly, for the lurking house trespass also the used by night has been replaced by sunset, sunrise. Then section 341 new act. Whoever possesses any seal, plate or other instrument knowing the same to be counterfeit shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable for fine. Similarly, new section 341 dishonestly uses genuine seal. These are all manipulated provisions which is not at all required. Then section 353, old section 505. False information including through electronic means are added. What is false information? Whoever publishes or circulates any statement, false information, rumor or report including through electronic means. Who has to decide which is the false information? I got an information. I pass on the information. Who has to decide is a false information? It is the only court has to decide. So therefore, it can be very well misused by saying whatever the information passed on is a false information. It will be tested by the court. Ultimately, this will be a futile exercise, but it can be abused. Then defamation is a very good thing, but when a defamatory statements are made, it is not necessarily to send to the person to the jail. He can be defamed or he can be allowed to go for community services, because the defamation is the most weapon nowadays we are using. big peoples for the purpose of punishing them in the name of defamation. The new section, last section is 358. This section is the most important section in all the repealing laws. The last section will be a section which will allow the act taken place in the earlier act will continue as if that law continues, as if those proceedings will be continue even though new act has come. But in this act, as far as IPC is concerned, the provision is not repealed. So therefore, it will be continuing efforts, continuing process. Therefore, the new act, IPC, has not given any repealing section. The Criminal Procedure Code is concerned, it is only procedure of law, except some modifications. Say, for example, we lodge a complaint to the magistrate or to a police. The police officer, if the punishment for the particular offense is less than 7 years, the new act says you give a notice to the person who has given a complaint, the victim. So you hear the victim and decide whether his case is required to be registered or taken cognizance or not, number 2. Number 3, if he is a person, he will not abscond. He is have permanent root in the country. Don't arrest him, execute him bail and release him on bond. Those cases which is below 7 years of punishment. And new provision of plea bargaining has been introduced. Though it was there in the earlier act of the Criminal Procedure Code, plea bargaining, the state of Tamil Nadu was never recognized that, but in the present act, plea bargaining has been come into force. So those cases where the punishment is less than 7 years, the first offender, and offences not relating to women and children, economic offences, on filing of a charge sheet, the accused has a right to file an application for plea bargaining. Then there is a procedure has been given whether he has come to the court with free of mind. In such circumstances, a inquiry can be conducted and the person can be given benefit of the plea bargaining, whatever may be fine or whatever may be the decision of the court. So this is the new addition the CRPC is concerned. Under the Evidence Act, the definitions have been included and deleted somewhere, but only major change is section 65 of the Evidence Act, which was relating to the electronic evidence. Because the definitions have been included wherever the facts have been there, electronic evidence have been included, therefore they have to give a certificate to that effect. There must be 2 certificates. One must be the owner of the computer, the other must be by an expert. So far, expert has not been defined or identified by the government. Therefore, these are all the changes in the 3 acts. But ultimately, the application of the amendment relating to the racialist movement or something is concerned, the already existing law is very much covering this field. It is the new act which tightened the noose, that's all. And ultimate thing is the court has to decide. I have pointed to 2 sections which are vulnerable and it can be misused. So therefore, on this occasion, I thank the organizers and our friends have given a lot of papers. You can get these papers for your satisfaction and decide. I thank the organizers and I thank Mr. Veerasegaran, K. Venkatamadi for giving me this opportunity. Thank you very much.
We thank our senior advocate. Now, I request our panelists to present their papers. First, advocate from Punjab, Dr. Harinder Lalli.
Jain San, to all the friends sitting on the dais and sitting off the dais. Exactly 2 years after, we are together again. Before 2 years, we were together at Barnala in the 12th conference of HERA, when I declared among you that I will go throughout the India on my scooter, for making awareness regarding the scientific temperament as per Article 51AH of Indian Constitution. Moreover, physical and mental health and some more good messages were to be given. Many of you met us, take care of us, and make so many arrangements for us during our ride. I am thankful to all of you, citizens of. My paper was some long, but due to stipulated time settled by the management, I am trying to cut short my paper. If anybody wants to read it as whole, you can ask me. I will send its soft copy to you by WhatsApp or through email. Recent amendments in criminal laws in India have raised concern about the potential suppression of activities by rationalists, activists, and citizens. I am quoting some key amendments that could affect this. Unlawful Activities Prevention Act, any UAPA, the definition of terrorist and unlawful activities and provision for preventing detention enables authority to hold individuals without formally charging them, which can be used to silence dissent. Provisions aimed to curbing fake news and misinformation can be misused to target activists and rationalists who challenge the dominant narratives or question established beliefs online. Sedition law, which was Section 124A of IPC, now Section 152 of BNS, Bharatiya Nyaya Sanhita. Provisions of hate speech, old Section 153A of IPC, new Section of 196 of BNS. Moreover, Section 295A of Indian Penal Code, now converted into Section 299 in BNS. This is more important for all of us. This section penalized deliberate and malicious acts intended to outrage religious feelings. Irrationalists advocating for scientific thought or critiquing religious superstitions may be charged under this vague provision. There are so many cases from Patiala in Punjab, Sarvit Ukhla, from Jangrao in district Ludhiana in Punjab, Surjit Dodar, and from district Mansa in Punjab, Upinder Pikhi. They are charged under Section 299 for writing a research book or some posting on the Facebook or social handles which quotes some scientific wordings. But due to the vague provision of Section 299 of BNS, they are booked under this case and under this section, under this law. So, however, there is an exception that there should be an intention to outrage the religious feeling of other people. But it will take very much time, long time to reach the court on a decision about our detention. On the other hand, authorities, police, other political parties, and some communal elements can harass us, can send us behind bars under this section. We should be careful from this. Changes following the longer remand periods can lead to delays in judicial process, keeping activists, rationalists in custody for extended time without trial. Before the new act, it was up to 15 days. Now, it has been made up to 60 to 90 days. Amendments relating to public order allows for arrest based on mere accusation of inciting unrest, targeting those who challenge the societal norms. Some amendments have reduced judicial oversight over the arrest and detention, making it easier for the police to act without accountability. The definition of unlawful activities under UAPA is broad and can be encompass various forms of dissent. Police can interrupt any critical speech or action against the government or societal norms as a threat to national security. So, these amendments create a legal environment where rationalists, activists, and citizens may feel pressured to self-censor or avoid engaging critical discourse. Moreover, the new criminal laws in India have had several negative impacts on the promotion of scientific temperament and rational discourse. Here are some more key concerns. Suppression of free expression, chilling effect, targeting dissent, marginalized rational discourse, detention without trial, limited educational initiatives, erosion of public trust, impact on research and innovation. These negative impacts can significantly hinder efforts to cultivate a culture of scientific inquiry and rational thought in India. Beside above problems, the police can misuse new criminal laws against rationalists, activists in several ways, like arbitrary arrest, exploiting prevention detention, targeting speech and expression, fabricating evidence, intimidation and harassment, bias and discrimination, lengthy investigation. These misuse tactics can significantly hinder the promotion of scientific thought and rational discourse. In summary, in the last, impact on rationalists. New laws may restrict the ability of rationalists to express dissenting opinions, particularly regarding religious beliefs or superstitions. Increased scrutiny and potential legal repercussions for campaign against the superstitions and pseudoscience can stifle rational discourse. Conversely, some laws may strengthen protection against the hate speech and incitement, supporting rationalists advocating for secularism. We should learn such laws thoroughly. Next, impact on activists. New laws might criminalize certain forms of protest, making it riskier for activists to organize and express dissent. The implementation of laws that allows for greater surveillance can lead to a chilling effect on activism, discouraging public mobilization. On the other hand, new laws may improve access to justice for marginalized communities, providing legal avenues for addressing grievances. The laws can impact public discourse, potentially stifling conversations about important social issues if activists and rationalists face legal challenges. Conclusion. Impact of new criminal laws on rationalists, activists, and citizens in India is complex and multifaceted. While some provision may offer enhanced protection, others pose risks to freedom of expression and dissent. Continuous engagement and advocacy are essential to ensure that these laws serve to protect rather than restrict fundamental rights. In last, beside my topic, I want to say only two things. Be mentally and physically fit. Be mentally and physically fit so that you can be a matured personality and you can build a strong nation of scientific temperament. Dr. Harinder Lal, advocate, is thanking to listen carefully all of you. Jai Insan.
Thank you, Dr. Harinder Lal. Now I request Mr. Venugopal from Tamil Nadu to present his paper. I request all the panelists to stick on the time because we are running out of time.
அனைவருக்கும் வணக்கம். Good afternoon everyone. So I am Venugopal, District Secretary of South Chennai for the Rationalist Forum. So today I will present on criminal defamation and its use against journalists and social activists. So an issue that affects democratic societies globally. So this research was conducted with contributions from Dr. S. Arutselvan and Mr. K. Periyar. So the definition of criminal defamation. It involves damaging an individual reputation through false statements punishable by imprisonment. Unlike civil defamation, which resolves disputes with monetary compensation, criminal defamation laws impose harsher penalties. Although these laws aim to protect reputations, they are increasingly misused to suppress journalists and activists, causing a chilling effect on press freedom. This misuse stifles investigative journalism and curtails democratic discourse. So, the background of criminal defamation laws. Historically, criminal defamation laws were designed to preserve social harmony and protect state or personal honor. However, their applications has evolved into tools to repression, particularly against journalists. Journalists face significant risk involving imprisonment of financial ruin for uncovering corruption or social injustices. This misuse often forces self-censorship, limiting investigative reporting and crucial public discourse. So, the global implications of press freedom. So, the research shows that criminal defamation laws are often misused globally. So, like chilling effect, intimidation tactics, and global cases. So, in the review of literature, studies by organizations like Freedom House and Reporters Without Borders reveal troubling patterns, like criminal defamation laws protect corporate interests over public good, deter journalists from exposing corruption or abuse of power. So, the methodologies. Our research uses a qualitative approach by using secondary data from global studies in 6 regions like Asia, Africa, North and South America, Europe and Australia. So these are some notable examples include like in India, Arvind Kejriwal and Arun Jaitley cases, the political rivalry turned into defamation suits, and USA, so domination voting system like Fox News, allegiance of election misinformation. And in Australian country, the case of Reville Wilson versus Bauer Media. So Wilson career was damaged by defamatory articles. So these cases show how criminal defamation laws can intimidate journalists and restrict critical discourse. So the discussions are, it suppresses journalists, activists and whistleblowers. So it limits critical discourse, impacting citizens' access of truthful information. So reforms are necessary to align these laws with democratic principles and protect journalistic freedom. So I conclude with that criminal defamation laws, as they are currently applied, pose of significant threat to democratic values. So reformers must limit critical defamation to only most malicious cases, and journalists must be protected from frivolous lawsuits, and independent bodies should oversee press freedom issues. And such reforms will balance individual reputations with the principles of transparency, accountability, and freedom of expression. That's it. Thank you. Thank you, Ananda.
ரெண்டு பேரும் உங்க பேர் சொல்லுங்க. Okay. Mr. Muttarasan and Angarayan Sundara Kaladharan, they both present their paper on impact of new criminal laws on rationalists, activists and citizens. A deeper look into the impact of BNS on activists.
A very good afternoon to everyone. And myself and my friend Angarayan together going to present the paper. So I'm going to present the first part of it. So the topic we chose, the impact of criminal laws on rationalists, activists and citizens. And we focus more onto the impact of activists. A disastrous start to safeguard democracy. Any democracy to survive, we need the laws are very basics. So that's how we had the 3 criminal laws, the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act. So the laws are very basics for the constitutionalism. And democracy will often become shaky structure when the criminal laws is a very strange and no attack on any social group or minority. That's how we see in the history when the criminal laws are more strange and punish the people and the citizens, then it moving towards the authoritarian. Most of the Asian countries, the democratically elected countries are fall down because of these laws. For instance, recently the government of Bangladesh has fell down, we know. But at the same time, the age-old laws were not appropriate to administer rule of law. So we need to make the extensive amendments to then the existing acts will drive the parliament through the famous ship of Theseus paradox. However, the manner in which the government has passed these laws are very crucial. They have passed these laws just suspension after almost 140 members of the parliaments. Almost the 20% of the members were absent, were suspended. This is not just a shaky, but the disaster restart for the foundation of the great dream India. A criminal justice system that is devoid of lingual justice. So our previous speaker, Advocate Kumaradevan also mentioned the way they kept the name for this law. So already we had the laws, so Indian Penal Code, the Code of Criminal Justice, the Indian Evidence Act. It's very simple. We can easily understand. But what they have done is, which I'm not, very good at pronouncing these words, Bharatiya Nyaya Sankita, Bharatiya Nagarik Suraksha Sankita, and Bharatiya Sakshya Abhiyan. It's a kind of Hindi imposition. They are come one after another way to impose the Hindi, and particularly on the southern states. That's how they wanted to achieve the one nation, one language, the one nation, one election, and etc., etc. Not all that glitters is gold. The gold plates, stone tables. The Union Home Minister, he was very, welcomed and the implementation of the 3 laws. But the way they implement, it's almost, very crucial. Almost 95% of the laws we brought from the criminal laws already exist. The colonial mindset, the structure of the colonial mindset has not changed. And this government is very famous for the renaming the existing one. That's how they did it on these laws as well. The section 124A in the IPC has become one of the most ill-used section of the code, was abolished But for that, instead of that, they have brought the section 152, the acts endangering sovereignty, unity, and integrity of India. So the definition of unity and integrity was not precisely mentioned. So what happened now? This new laws has widened the ambit of the act, has brought in the more ambiguity into the interpretation of the same. So the existing law itself already had a lot of issues, and they had a lot of misuses, but they have widened up the misusing this power and the laws. While the welcome changes is code by inclusion of online, the digitalization of the online FIR, the strict punishment for offences against women and children. Apart from that, these laws are it's against our democracy. It's against the people of India. The Tamil word for both frame and law is sattam, which shows the close dependence of each of these concepts. A law that is formed within an archaic frame cannot be the basis for a modern society. A more libertarian and evolved approach is required to govern the society and crimes in this modern world. The second part, my friend will continue. Thank you.
Fine. Thank you, Muthu. I am Angarayan, and before before I start the speech, I just want to make a small disclosure that I have a stuttering, so at times I might exaggerate the words. So please bear with me. Fine, thank you. So okay, fine, thank you. So I mean, like, okay, first of all, the reason we are discussing about the laws has to be clarified. Like, for every democratic society, there is a need for constitution, and that is like without the constitution, or without a strong and dynamic constitution, the democracy will slowly sink into despotism, and that has been happening in all the other countries in the South Asia. So, okay, so that is the, and then for a proper constitution to be there, we need social order and social harmony. These three laws are instrumental in ensuring those social order and the social contract. So it is necessary to discuss and deliberate about these laws. So the scope of the paper is the VNS on the activists alone. So, like, since it is an academic, since it's an academic topic, unlike the other topics, it will be hard to explain the sections and barracks. Instead of that, with the anecdotes and the current affairs, I think it will be better to proceed. So alt news is a alt news is a famous fact. Okay, Alt News is a famous fact-finding organization, and Mr. I'm sorry, and Mr. Mohammed Zubair is the co-founder of it. When recently, for sharing when sharing and making an awareness about the videos of Yeti Narsingh Anand, he was booked under the section 496 of the BNS. And after a few days, he was additionally booked under the section 152 too. So the 152, as everyone said, is a blanket act, and it can be interpreted widely. So the 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 I'm sorry, the act penalizes the person
run, this will result in incalculable damage to the progress of Indian science and to social harmony. Therefore, it is clear that it is not only the religion-based belief system practiced by the common people that